We will be dealing with some of the basic questions related to tort law for enlightening our knowledge in the subject of law. So, without wasting any time, let's start with it. The first question is, tort is a violation of what? The options are A. Neither right in personam nor right in rem. B. Both right in personam and right in rem. C. A right in rem. Or D. A right in personam. The correct answer to this question is option C. That is, tort is a violation of right in rem. The next question is based on a principle that the principle of absolute liability says that a person is absolutely liable for all the consequences of any dangerous substance that he brings onto his land, and no one can be penalized for the act of God which is unforeseen and unpredictable. Based on the principle, the facts are Anderson is the managing director of a company that makes fertilizers. One of the plants on the company's campus at Kochi utilizes a lot of toxic gases to make the end product. Anderson ensures that every possible precaution and preventive measures known to a man has been taken to prevent any disaster. However, one night the plant is struck by lightning and a lethal dose of poisonous gases escape and kill 600 people, and injuring at least 2,000 others. Is Anderson's company liable for the accident? The options are A. No, since the lightning was the act of God and not foreseen. B. Yes, because they developed a dangerous process on their land and hence absolute liable for all the consequences. C. None of the choices. Or D. No, both, because all precautions have been taken. The correct answer to this question is option B. That is, yes, the company will be liable because they developed a dangerous process on their land and hence are absolute liable for all the consequences. The next question is, which of the following is not correct about joint wrongdoers? Two persons are joint doers when the options are A. They commit tort in concert. B. They act in pursuance of unlawful conspiracy. C. The combined effect of their wrongful acts is the enhancement of injury. Or D. One acts under the authority of another. The correct answer to this question is option A. That they commit a tort in concert. The next question is, which of the following facts do not include within itself the principle of joint liability? The options are A. An act done in a furtherance of the intention to cause harm. B. The actuated act need not be a crime or when it is foisted. C. An act done in a pre-arranged plan between more than one person. Or D. Mere participation in some other in the act constituting the offence. The correct answer to this question is option B. That is, the principle of joint liability is brought when the actuated act need not be a crime or when it was foisted. The next question is, for a person to succeed in a suit for malicious prosecution, which combination from the five factors must be proved? First, the factors are first, the prosecution has ended in favor of defendant. Second, prosecution has ended in favor of the plaintiff. Third, presence of malice. Fourth, the absence of malice. And fifth, prosecution was without reasonable cause. The options are A. First, fourth, and fifth factor are correct. B. The second and the fourth factor is correct. C. Second, third, and fifth factor are correct. Or D. First, third, and fifth factor are correct. The correct answer to this question is C. That is, the second, third, and fifth factors are correct. The next question is, the doctrine of contributory negligence is not applicable when the negligence is committed by who? The options are A. State, B. Child, C. Woman, or D. None of the above. The correct answer to this question is option B. That is, the doctrine of contributory negligence is not applicable when the negligence is committed by a child. The next question is, X residing in Delhi publishes statement defamatory to wife in Calcutta. Y can sue X at which of the following locations? Options are A. Either in Delhi or in Calcutta, B. Delhi, C. Anywhere in India, or D. Calcutta. The correct answer to this question is option A. That is, either in Delhi or in Calcutta. The next question is, an overloaded rickshaw with the three adults and a child on it, while being driven on the correct side of the road, is hit by a bus driver at a high speed, which was coming on the wrong side. Which one of the following is correct in this context? Option A. The bus driver and the rickshaw driver both are liable for the accident. B. The bus driver is not liable as the rickshaw driver had a last opportunity to avoid the accident. C. There is a contributory negligence part of rickshaw driver as he had overloaded the rickshaw. Or D. There is no contributory negligence part of the rickshaw driver as there is a fact of overloading did not contribute to the occurrence of the accident. The correct answer to this question is option D. That is, in the above situation, there is no contributory negligence part of the rickshaw driver as the fact of overloading did not contribute to the occurrence of the accident. The next question is based on the principle that false imprisonment is a tort, which means that the total restraint of a person's liability without lawful justification. Based on the above principle, the fact is that a part of public road has been closed for spectator of a boat tea race. P wanted to enter, but he was prevented by D and other policemen because he had not paid the admission fees. P was able to enter the enclosure by other means, but was unable to go where he wanted to go. The policeman refused access to where he wanted to go, but allowed him to remain where he was, or to go back. P remained within the enclosure and refused to leave. Subsequently, P sued D for false imprisonment. In the above said fact, which of the following options are correct? The options are A. It was a case of false imprisonment, but D could not be made liable for it. B. D could not be made liable for the false imprisonment as he did not totally restrain P's movement. C. D could be made liable for the false imprisonment as he did restrict P's movement. Or D. D could not be made liable for the false imprisonment as he has not touched him. The correct answer to this question is option B. That is, D could not be made liable for the false imprisonment as he did not totally restrain P's movement. The next question is based on the principle that a service provider is liable to his consumer for any deficiency in service under the Consumer Protection Act 1986. Based on the above principle, the fact is that Mr. Frank is running a restaurant on Mumbai Goa Highway. John, a foreign tourist, on his way from Karnataka to Mumbai, stopped at Mr. Frank's restaurant for dinner. The restaurant was providing boarding facilities to its customers free of charge. After dinner, John decided to sleep for a while before resuming his journey. John slept due to exhaustion, but his sleep was disturbed because of persistent attack by bed bugs. Further, rashes also developed on his skin due to the bug bites. John loves the consumer for relief. What are the chances of his success? The options are A. John will not succeed as admittedly he slept and hence there was a deficiency in service for the restaurant. B. John will succeed because the boarding facility was provided by the restaurant only to its customers and hence will be falling with the ambit of service under the Act. C. John's success in getting relief will depend upon his ability to prove some loss or damage due to negligence of the boarding administration. D. John will not succeed as the boarding facility provided by the restaurant was free and will not fall under the definition of service within the purview of the Consumer Protection Act 1986. The correct answer to this question is option B. That is, John will succeed because the boarding facility was provided by the restaurant only to its customers and hence will be falling within the ambit of service under the Act. The next question is trespass to goods is options are A. Not actionable, B. Actionable per se, C. All the above choices, or D. Actionable only when damage is caused. The correct answer to this question is option B. That is, trespass to good is actionable per se. The next question is the way in which a right or action for a tort may be discharged is options are A. Death of the parties, B. Accord and satisfaction, C. Waiver, or D. All of the above choices. The correct answer to this question is option D. That is, all the above choices, that is, death of the parties, accord and satisfaction, and waiver, are the correct answers and the action for a tort. The next question is in law of tort, A. Mistake of fact is a defense, B. Mistake is not a defense, C. Mistake is a good defense, or D. Mistake of law is a defense. The correct answer to this question is option E. That is, in law of tort, mistake of fact is a defense. The last question is match the following. List 1 with list 2. List 1, A. Bis major, B. Res ipsa loquitur, C. Actionable per se, or D. Voluntary non-fit injuria. List 2, first trespass, second act of God, C. Negligence, third negligence, and fourth 17 non-fit injuria. The options are A. Second, third, 1, 4. B. Third, second, 4, 1. C. 4, 2, third, 1. Or D. Second, 1, third, or fourth. Correct answer to this question is option B. That is second, third, 1, 4. That means to say, vis major is related to the act of God. Res ipsa loquitur is related to negligence. Actionable per se is related to trespass. And voluntary non-fit injuria is related to 17 non-fit injuria. Thank you for listening and grasping the knowledge.